opportunities for state regulation of online content. Our new center launched just last week, so it's really exciting to have an opportunity to get together today to have a conversation on an important issue in online expression. A few quick things to introduce our center. Our mission is to develop public policy for a better internet. Our goal is not simply to articulate the challenges we face today, but to develop concrete, actionable policy frameworks to make the internet better tomorrow. We're supported by a diverse group of funders ranging from companies like Amazon to companies like Zoom, and from foundations like the Knight Foundation to others like the Charles Koch Foundation. You can find more about our funders on our website. And if you're interested in learning more or getting involved in our work, please send an email to info@techpolicy.unc.edu. We have a fantastic panel today. We have a sitting state policymaker. We have one of the world's leading experts in free expression. We have one of the people who was principally responsible for stopping legislation in Florida and Texas on the basis that it violated the First Amendment. And we have an extraordinary scholar in First Amendment and media law who also happens to be a member of the wonderful community of technology scholars we have here at UNC. What a group. So with that, I will turn it over to Scott Bobwar-Brennan, the head of online expression policy at our center, to get us started.
Great. Thanks, Matt. And thank you all for coming. So I guess the place to start here is what's wrong with online content? The two big pieces of hold on, sorry, I have to say, please excuse me, I'm also running the technical side, and I think there's going to be a few hiccups here and there. So right, the two big pieces of like tech policy news of the past few weeks are, the passing of the DSA and Elon Musk buying Twitter are both fundamentally about efforts to improve content online. And I think these two stories, right, point to the two big problems that people see with the conversation online. On one hand, one of the key things that the DSA will do is to compel platforms to act to remove problematic or really illegal content, and is indicative of this concern that there's just too much illegal and harmful content online. And on the other side, right, we don't really know much about Elon Musk's plans, but if we're being generous, we might say that at a minimum, he's concerned about overly aggressive content moderation that limits legal speech. And these two stories, I think, are also, though, indicative of one of the kind of key biases that we have in tech policy more broadly, right? We tend to focus on what major platforms are doing or on this sort of national or international regulation. And there's good reason for this, right? It's understandable why we have that sort of bias. But over the past few years, states have been really stepping up their work in tech policy. And we've seen some really interesting legislation from the states in the areas of privacy or taxes, and of course in content. And so we have invited this amazing panel here to discuss this question of how states can or how they should regulate online content. And I'd like to divide our time into two big parts today. The first half, it's really about setting the scene. And we'll talk about the sort of legal and political constraints on states to regulate platform content, and also sort of what are states currently doing. The second part, though, I want it to be more affirmative, more positive. And I'm going to ask the panelists to talk more about what states can do, what they should be doing in this area. And I'll say, maybe the answer to that question is absolutely nothing. And I'm not sure if any of the panelists feel that way, but if they do, great. And that I'll also just throw out a plug. Last week, CTP, we just published a guide or a sort of a menu for states with 13 different actions that states can take to improve online content, actions that are likely to be legal, let's say, and we think positive here. And I may refer to some of the ideas that we suggest, but I really don't want us to stay too close to the report. I want us to have a sort of a wider ranging conversation here. I'll also say that we'll have some time for Q&A at the end, but please post any questions that you have in the Q&A box. I'll keep an eye on that. And no promises, but I might try and weave in some questions into the discussion that we have. Okay, so on to introductions. So as I said, we have this incredible panel, and so in no order here. First, Emma Lanzo is the director of the Center for Democracy and Technology's Free Expression Project, where she works to promote law and policy that support internet users' free expression rights in the US. Europe and around the world. Emma's work spans many subjects, including human trafficking, privacy and online harassment, online child safety, terrorist propaganda and disinformation. She also leads CEDT's advocacy focused on protecting fundamental rights to freedom of expression and preserving strong intermediary liability protections as a core element of legal frameworks that support free expression online. Okay, Delegate Wendy Goditis is a member of the Virginia House of Delegates. She is vice chair of the House Committee on Agriculture, Chesapeake and Natural Resources, and she sits on the House Committees on Labor and Commerce and Counties, Cities, and Towns. She's also chair of the Interstate 81 Committee and serves on the Center for Rural Virginia Board of Trustees, among other appointments. Steve Del Bianco, as president and CEO of NetChoice, Steve's mission is to make the internet safe for free enterprise and free expression. To that end, he's provided expert testimony in 25 congressional hearings and over 150 state legislative sessions, which is kind of mind-boggling to think about, and has appeared across media outlets. Before his work at NetChoice, Steve was founder and president of Financial Dynamics, an IT consulting firm that he led through the evolution of technologies and sold to a national firm in '97. And he holds degrees in engineering and economics from the University of Pennsylvania and an MBA from the Wharton School. Finally, Mary Rose Papandrea is the Samuel Ash Distinguished Professor of Criminal Law at the University of North Carolina School of Law and head of UNC's Strategic Initiative to Promote Democracy. After graduating from Yale College and the University of Chicago Law School, she clerked for U.S. Supreme Court Justice David Souter and practiced law at Williams and Conley LLP in D.C., where she specialized in First Amendment and media law litigation. Professor Papandrea has written and taught very widely across topics related to First Amendment, media law, civil procedure, torts, constitutional law, and national security. As I said, we're just so grateful for all of you for coming and joining today. And I'm really excited to hear what you all have to say about this. So I'd like to kick things off with a question for Mary Rose. So can you please give us a sense of some of the sort of legal limitations on states trying to regulate platform content and/or content moderation? In particular, how the First Amendment and other federal law constrains states.
Yes, sure thing, Scott. First, let me just say how excited I am to be here to celebrate the launch of this new center. In my capacity as head of the university's strategic initiative to promote democracy, we have real strengths here at the university, studying social media platforms and our information ecosystem more generally, in addition to the Media Law and Policy Center, which is a joint venture between the law school and the Hussman School for Media and Journalism, and CTP, which is the Center for Information Technology and Public Life. UNC just launched the Wilson National Center on Technology Use, which focuses on the impact of technology and social media on adolescent brains. This center and all of these centers demonstrate the depth of the expertise we have here at UNC in these centers, in our schools, SILS, the law school, Hussman, School of Ed, social work, public health, medical school, and I'm going to just stop there. I could go on. This is a great place to have a center like this because you're going to have a lot of synergies around campus and people who are interested in studying some of these issues. So welcome and good luck with this new center. So I'm going to just say a couple words we could have an entire panel, an entire day, maybe a week talking about First Amendment issues. So I'm just going to kind of go high level here and happy to go deeper on Q&A if there's interest. First, let me just say social media companies are private actors. They are not government actors. So if they were government actors, their content moderation policies would have to be consistent with the First Amendment rules that the Supreme Court has developed. The First Amendment protects a lot of speech that many of us don't want to see on social media, including, for example, pornography that doesn't arise to obscenity, most false speech, except for, say, defamatory false speech, and speech advocating unlawful conduct that doesn't constitute incitement. And I could go on. So our First Amendment protects a lot of speech. If platforms were state actors, they would have to follow the First Amendment, but they don't. And that is given them the freedom to create these content moderation policies. If the state passes a statute forcing social media companies to take down protected speech, that would be a First Amendment violation, because it's the state, a government actor, requiring the censorship of speech. And unless those categories match up with the First Amendment doctrine from the Supreme Court for unprotected expression, we would have a First Amendment problem. If the state government requires social media companies to support or host certain types of speech, that would also arguably be a First Amendment violation, because the First Amendment prohibits compelled speech, prohibits private actors from hosting compelled speech. So just for imagine, the government could not tell the New York Times to run a particular story, just for example. Now, you may have noticed I said the word arguably, because this issue has not been litigated, and there are some people who argue that it would be possible to compel social media companies to publish speech they don't want to publish. I don't personally take this position, but it is not a frivolous argument. Justice Thomas has made this point in an opinion he issued in the Knight Institute v. Trump case that was dismissed as moot. He has suggested that platforms could be regarded as common carriers, like a phone system, or a place of public accommodation, like a retail store. I've also heard people like Eugene Volokh argue that no one would think that the social media companies are endorsing the speech on the platform any more than it would be appropriate to say that the government endorses speech in the town square. But the problem here, I would say, is that social media has always been a place where the platforms organize and gather and arrange information into the feed. The whole point is to determine what information to get to users, and they've always been doing that. So the parallel with a common carrier doesn't, in my view, line up, but we can talk more about that on the panel. Finally, I'll mention that we've seen some increasing efforts to require transparency. So require divulsion of the algorithms, for example, or how they make their decisions of what speech to permit and what speech to take down. This is going to be a great area for litigation, also not determined. There are some serious First Amendment concerns here as well. And again, I just urge you, just think if the New York Times were asked to reveal the internal workings of its editorial functions, that would clearly be a First Amendment violation. And there could be other constitutional concerns, statutes that are vague, so that's a drafting problem often. Due process issues can also come up. Finally, and then so I can stop talking and let everyone else speak, I just want to say a word about Section 230 of the Communications Decency Act. This is a federal law, and there are a lot of provisions of the Communications Decency Act that the Supreme Court struck down as unconstitutional, but there is this remaining provision, Section 230, which in broad brush essentially provides that platforms have immunity or cannot be held responsible for user-generated content. Now, let me be clear, this does not provide any protection for users themselves. Users themselves who create this content can still be held liable consistent with the First Amendment. Section 230 also carves out IP law, violations of federal common law, and essentially state and federal sex trafficking laws. Absent a repeal of Section 230 or some sort of big revision, the federal law expressly preempts state laws that seek to hold platforms civilly or criminally responsible for user-generated content in any way that's inconsistent with Section 230. So that, I'm going to stop. Lots more to say, but I hope that gets us started.
Yeah, thank you so much. That was an amazing answer to a really hard, big question. But yeah, you managed to cover a lot of ground, and I'm sure we'll come back to a lot of the topics that you brought up there. So I'd like to turn to Delegate Gudaitis. So Mary Rose has given us the sense of the sort of some of the legal limitations on states in acting in this area, but I'd love to hear more about the sort of political realities of passing legislation at the state level. So you, of course, introduced a bill on platform regulation earlier this year. And then in the second half, we'll talk a bit more about what the bill actually proposes, but right now, I'd actually like to hear more just about your experience of navigating the political reality in the states, like the political divide. Like, what's it like to actually work to pass a bill through state government?
Or not to pass a bill through state government, as it were. First of all, I want to say I am not a legal mind, all right? And I am not someone who had a lifelong ambition of getting into politics. I backed into this job because of my horror at discovering how the Virginia legislature was not protecting, in fact, was doing damage to millions of Virginians. And whether it's access to health care, whether it's not paying a livable wage, there are all kinds of things. So I got here to care for people and very specifically to save lives. There is what's legal, what is based on legal precedent, and there is, in my opinion, what's right. And what's right is to try to protect my constituents, Virginians, Americans, from the damage that a rampant Wild West social media is doing and the lives that it is damaging and destroying. This bill that we put through, from my point of view, it was a completely partisan process. The bill was going to be a first step in dealing with this problem. It was immediately sent to the Rules Committee in our legislature, which is stacked 13 of the majority, 5 of the minority. In my case, in the Virginia House of Delegates, it's a Republican majority, 13 Republican members, and 5 Democratic members. It died on party line vote. The comment from a dear friend of mine who happens to be a Republican, but his comment appalled me. It was that this issue is too big. It's too big. I was raised in a family where you go after a problem, especially one that is hurting other people. And the size of the problem makes it all the more important that we try to find what we can do. So from where I sit in a minority in the House of Delegates in the Virginia legislature, this looks like a partisan problem. I hope it isn't. I hope that people are understanding that the teenagers who are committing suicide, the people who are dying in riots, the members of Congress and the U.S. Senate who are endangered in seditionist acts against the Capitol are Republicans and Democrats. And so for me, it's a tough process. It's something that I'm not giving up on. And if the federal level is not tackling this fast enough, then the states must do something. Here in Virginia, not only did we have the members of our National Guard going to the Capitol, getting there before any U.S. military went there to protect the Capitol Police and the Congress. So that was Virginians there. We have members of Virginia in school boards in Virginia, incredible numbers of death threats and dangerous meetings. All of this ramped up on social media. We had the Charlottesville white supremacist marches where people died, and all of that ramped up on social media. Virginians are dying. Virginians are in danger, and the Virginia General Assembly ought to be paying attention and trying to do something about it.
Great, thank you so much for that. What an interesting kind of response from your Republican colleagues that the problem is too big. Like, I'm not sure how that makes you feel. It's like, well, what? So we should only be approaching, I guess, the small, easy to attack problems. Great. Well, thank you so much for that. So Steve, NetChoice has been doing, a great deal of work recently on state legislation, including filing lawsuits against the only two of these bills that have actually been signed into law that specifically targeting content and content moderation on platforms. So could you please, describe these two bills in Florida and Texas, NetChoice's positions on the main provisions, and maybe talk a bit about how these bills are sort of indicative of, the action happening in other states as well.
Yeah, thank you, Scott. And Scott and Matt, congratulations on the new center and also the new paper. Read it with great interest. And I think you have really done a great job assessing the current landscape. And I applaud many of the ideas that you're proposing going ahead. Delegate Gudaitis talked about the problems in a legislature like Virginia, but Congress is a different kettle of fish. In Congress, as you acknowledged in your report, there's been no meaningful reform on content moderation. And you suggest it's because they have mixed motivations in Congress. But, to be real, you should have said that Congress, the parties have completely opposite aims, right? The Democrats want greater amounts of content moderation, not just to protect, say, teenage girls, but to stop what Democrats believe is disinformation about election integrity or disinformation about health or reacting to COVID. On the other hand, Republicans are demanding the social media moderate less. So it's completely opposite aims because the Republicans want to pressure and work those referees to allow more speech to be up. So in the middle are my members. So I run NetChoice, a trade association. So my members are folks like Amazon, Facebook, Google, Twitter, and many others listed at the website. And those social media platforms sit between a two-sided market. They've got consumers, users on one side, and we've got advertisers who pay for everything on the other. And our goal is to take content from our users to ensure that it matches our community standards so that we don't offend a lot of users or offend advertisers. So that's a delicate balancing act. And that balancing act is incredibly difficult to get right. All of my companies ended up kicking off Donald Trump after January 6th. And sure enough, that ignited a firestorm of upset red states because Delegate Gudaitis quite correctly describes the atmosphere in Virginia because Virginia, being a red state, is going to probably force my members to do less content moderation, not more, because the stalemate you see in Congress, where both sides have opposite desires, is not present in a state where there's a trifecta. Trifecta being that one party holds the Senate, the House, and the governor's mansion. So let me turn to what happened in Florida last year. Florida holding a Republican trifecta and with a presidential wannabe in the governor's mansion, Governor DeSantis was the first to champion a law which would tell social media platforms you could not restrict content based on viewpoints that were expressed. And journalistic enterprises would be completely exempt from content moderation, as would any candidate for public office. And he targeted large social media sites. But he carved out an exception for social media that's run by any company in the state of Florida that runs a large amusement park. And that's Disney. And as you probably know, last week, Governor DeSantis ripped the scab off of that one by suggesting that Disney wouldn't be exempt from his law. Now, NetChoice is more of a right-of-center trade association. And so we took it upon ourselves to run into Florida and to testify at every hearing they had to explain that the First Amendment, as Professor Papandreou talked about, the First Amendment would prohibit the state of Florida from forcing social media to carry content we didn't want to carry. And then we said that even if you could somehow find a law that survived constitutional challenge, it's going to result in some awful but lawful content showing up in the front of all Floridian social media users, things like pornography, child safety concerns, hate speech. Think about the nudity, violence, and worst of all, for many people, is the spam that would result. So that sort of lawful but awful content would be a terrible embarrassment for Republicans, who would be seen as the ones who were responsible to stopping my companies from moderating all of this content. So those arguments persuaded a few, but not enough. And sure enough, that bill was signed into law, and immediately NetChoice sued to block the law in federal court. We were fortunate to obtain an injunction almost immediately. The law was stopped before it went into effect. a 30-page ruling by a federal judge, and I'm no lawyer, I'm a programmer and a businessman, but it was easy for any non-lawyer to read that opinion, where the judge eviscerated the state law for completely ignoring what the First Amendment actually says. And I think that Professor Papandreou did a great job talking about that. It went on to say, though, Professor, that the state has argued that our members are common carriers. And the judge said, well, they're not, but even if they were common carriers, a common carrier does not lose First Amendment protections from actions of the government. Cases like PG&E and others indicate that a common carrier is still cannot be forced to carry content by a government that it doesn't want to carry. So it's sort of a neither here nor there discussion on common carrier. I'll just give you this as well. Governor Abbott of Texas, not to want to be outdone by presidential candidate rival DeSantis, also introduced legislation that passed late last year, very similar to the Florida law, although it didn't have an exemption for Disney. We also sued in Texas and also obtained an injunction against the Texas law. Different judge, different court, but a very similar opinion, both in terms of First Amendment problems and in terms of the idea that a common carrier doesn't change the ruling at all. I'll give you one quick update. Yesterday, the governor of Florida appealed that ruling, and oral arguments were heard yesterday at the circuit court in Alabama. And sure enough, the three-judge panel who asked all the questions indicated this was really all about the First Amendment. Nobody mentioned the word Section 230, and nor did NetChoice talk about Section 230 as an important consideration here, because it needs to be about the First Amendment. And Section 230, which was really just designed for lawsuit abuse, is sort of really not on point as much as some people think that it should be. Now, in Florida yesterday, their attorneys argued that they know that the First Amendment blocks their law, but they said the First Amendment doesn't apply to social media at all, claiming that social media is just a bunch of blind, dumb conduits where everything I type shows up on the website. And that belies the whole point that we do content moderation to keep users happy and advertisers happy. At the very end of the argument, when it looked like it was going downhill for Florida, they tried to save pieces of their law through the severability clause to see whether they could preserve some of the transparency and appeal mechanisms in it. So these are indicative of what's happening in a lot of states. We've had 16 states try similar things this year so far that have tried and died, but there are still 8 bills still alive. And we can discuss some of those in the second half of your program. Thank you.
Right. Thank you, Steve. That was fascinating. So Emma, I'd like to turn to you now. And we know that legislation is not the only way that states are trying to regulate content or change content online. And so, Emma, I'd like to ask you about your recent amicus brief in support of a rehearing in Twitter versus Paxton. So maybe you can just tell us what's happening in this case for those who are unfamiliar with this. What is CTP's position, and how does this case kind of relate to state action on content moderation more broadly?
Yeah, absolutely. And thank you so much to Scott and Matt for having this panel, and congratulations on the launch of the new center and the report. I just love the focus that you have on concrete and practical actual solutions to all of these many problems that lots of us spend a lot of time admiring. The case of Twitter versus Paxton is a really interesting one because it's a good example of how, so we've heard from Professor Papandreou and from Steve, the very many different kinds of First Amendment issues that can arise with state legislation around content moderation and how online services decide what content they will or won't have on their services. But that's not the only kind of state action that might raise First Amendment concerns. So what happened in the Twitter versus Paxton case is the Attorney General of Texas, Paxton, issued what's called a civil investigatory demand, a demand for information potentially pertaining to a case that he might want to bring. This CID demands that Twitter turn over its internal documents about how Twitter moderates content. And the pretext for the CID was that AG Paxton was looking at whether Twitter was in violation of the Texas Deceptive Trade Practices Consumer Protection Act. So Texas has a Consumer Protection Act that prevents companies from engaging in deceptive practices, and on the face of it, the CID was about, concerns that Twitter was somehow deceiving or misleading its users in describing its content policies and content moderation in one way, but actually doing something different. But AG Paxton along the way was also making a lot of different public statements that made it clear that the real underlying motivation for this civil investigatory demand was to retaliate against Twitter for exercising editorial discretion over, in particular, whether to host then President Donald Trump's account on Twitter. So this CID came after January 6th, after the decision by Twitter to remove Trump's account and the decision by a number of other social media services to do the same, and was really clearly framed as the Attorney General disagreeing with this decision that this private company had made and using all of the tools in the toolbox that he could find to try to go after that decision. This really starts invoking a core question around social media services that Mary Rose and Steve have mentioned already, the sense that when online services are making decisions about what content they won't host, that is First Amendment protected activity. That is the private actor exercising editorial discretion, sort of along the lines of how the New York Times does when it decides whether to run letters to the editor or not, sort of how a book publisher does when it decides whether to publish manuscripts that are submitted to it. And it can be sometimes, I think, maybe challenging for folks to think about content moderation in that frame because the scope and the scale of what happens online is so much vaster, and so many more of us have that kind of direct engagement with it than, I don't know about you, but I've never just sent off a manuscript to a book publisher. And so there can be a little bit of the sense that, like, no, these are just platforms that kind of have to take my content, have to take my speech, as Steve was kind of alluding to those people making those arguments earlier. But in fact, online services are making a lot of different kinds of decisions, including decisions at scale that they might enforce through things like content filters, and really articulating a set of policies and standards around what they do and don't want to host for different reasons. Different online services can have very, very different content policies because of the kinds of speech that they want to enable, the kinds of communities that they want to enable, which speakers they actually want to make sure have room on their service to speak. If you're trying, for example, to host an online service that supports people talking about different mental health issues that they've had or challenges that they've had and find outreach and support from each other, you're probably going to moderate that service pretty heavily to ensure that there's not off-topic content, to crack down on abusive content or any harassment that might happen between users, because you're trying to cultivate an environment that really allows that particular kind of speech to happen. So there's a lot of really sort of editorial-like judgment that is happening when an online service makes its content policies and enforces its content moderation system. And our concern in the Twitter versus Paxton case is that having the civil investigatory demand kind of hanging over Twitter's head, saying that Twitter had to turn over internal documents, including prospectively from the time the demand issued, all of their sort of record keeping about decisions they were making about enforcement against different accounts or changing their policies or how they enforce their policies, knowing that there might be this kind of scrutiny and this risk of kind of retaliatory enforcement against them for their demands might actually chill Twitter in how it moderates content. And that this is not only a burden on Twitter's First Amendment right to exercise editorial discretion, but it's bad for users. It's bad for users if online services don't have the kind of flexibility to respond to changing environments, different kinds of challenges or problems or threats that might arise that their policies maybe didn't account for previously. And it keeps people from being able to find services that are kind of operating free of this sort of government coercion and government control. We think especially enabling a civil investigatory demand to kind of just hang out there in the ether. The legal question at issue in the case is whether the case is ripe for Twitter to bring this First Amendment challenge because the investigatory demand has not been enforced. The AG has not required by law that Twitter turn this information over or brought any sort of penalties against Twitter yet. But our argument is that just even having that demand hanging out there will cast this kind of chilling effect on Twitter and likely on other platforms who understand that if the Attorney General is not happy with how they are doing content moderation, they may face that same kind of searching inquiry. And so just one thought on the kind of the bigger picture here, we are seeing a lot of this kind of aligns with the conversation around must carry ideas, the idea that online services must carry everyone's speech, the sort of common carrier idea that we've been discussing. But it also is looking at this particular sort of concept around unfair and deceptive trade practices as maybe a lens through which to look at content moderation. And that's interesting, that it's definitely interesting to look at more of a consumer protection model around content moderation rather than a strict, policing whether an online service is taking down illegal content or not. Looking more systemically at what online services are doing makes a lot of sense in some ways, but it's still really important to understand that there are the ways that content moderation works on different services. There are going to be errors. There are going to be vagueness. It's basically impossible to write out a set of content policies that perfectly encapsulates everything a service provider might ever want to take action against, partly because people are very creative and will come up with ways to circumvent any policy that you write down and still try to get disinformation or hate speech or whatever else the service is trying to block onto the platform. So the idea that we can have a perfectly articulated set of policies that can be rigidly enforced as, if the provider deviates from that policy, they are being deceptive in some way, it really just doesn't align with the technical practicalities of how moderation works. So I'll stop there because I know there's a lot more to talk about. But yeah, I think this case really points to, in addition to all the questions around legislation, there are so many different interesting ideas and potential First Amendment pitfalls for other kinds of government action as well.
Great, thank you. Yeah, this is a fascinating case, and you're I totally agree that it raises a lot of really interesting questions in this space. So I want us to transition to part two, act two of the panel, and I really want us to try and be kind of affirmative, be positive on can we we've heard 30 minutes of all of the things standing in the way of states doing anything in this area. And those are very, very significant real challenges. But given all of this, what can and what should states do? That's what I want us to really focus on for the remainder of the time. So actually, I think I want to just, Emma, continue on what you were talking about as far as UDAP prosecutions. This was something that we ended up recommending in the report, that states can prosecute, I think we say, systematic and egregious violations of terms of service under these UDAP laws. Although, to be honest, that we went back and forth on this one. We thought a lot about is this actually a good idea? And so I would love to, I can just open this up to all the panelists, I guess, if there's anyone who wants to jump in here. What do you think? Is there value here in UDAP enforcement? Do the risks outweigh the benefits? I don't know who wants to jump in, but.
I could try one quick answer. I think it was sensible for you to suggest that, Scott and Matt, because every state can already bring unfair and deceptive trade practices acts. And I like the way that you framed it in your report. You suggested that it makes sense where the platform has made explicit promises about what kind of content it will entertain and what it won't. But there is no promise, explicit or otherwise, that every platform will be universally unbiased, fair, and impartial, which is the phrase that was used a lot by Fox News talk show hosts. There's no promise like that. That isn't an explicit promise. And therefore, any case on unfair and deceptive trade practices is going to have to suggest that the evidence that they gather would allow the Attorney General to say that the company said they would remove pornography and hate speech, but we have all these instances where they failed to do so. And would that failure constitute that knowing failure? Was it negligent on the part of it? And have people been harmed? If that can be found through the evidence, Scott, I think it's a smart move. Be careful, though, of what Emma's described. The political motivations of the Attorney General will probably play an outsized role in determining which kind of content they do an investigation of and which platforms they decide to go after. And I'll close just by suggesting that a platform is free to change its rules anytime it wants, and all of the platforms reserve the right to interpret the rules in any way they wish. Just like you said, you could not force the New York Times to describe the specific rules they use to determine whether to take my letter to the editor. nor could you force Twitter to explicitly lock into place the rules they'll use to allow tweets to stay up. Elon Musk is buying Twitter on the promise and the hope that he's going to change the rules for how Twitter moderates content. Donald Trump has launched Truth Social, and a competitor to Twitter, where he has a set of rules that say that Truth Social will take down any content that's critical of the Trump family. They're also said they're going to take down content that's not family friendly. So they're going to end up trying to moderate content to please an audience, and they'll change the rules over time as new threats emerge.
Yeah, that's great. Emma, did you want to kind of respond to that? Maybe share kind of your thoughts on UDAP enforcement.
Yeah. I think, like Steve said, I think there's definitely interesting directions to explore with this. And I liked how you all framed it in the report about, what was it? Systematic and egregious violations, egregious and systematic violations, because I think that's really where the factual question is going to come into play, and thinking about kind of what Steve was saying around what are the promises that service providers make. I would also be very curious to see how enforcement action on terms of service, what kind of influence that had on what companies are willing to put down in black and white about what they are promising. There's a risk, at least for some services, that it might actually encourage them to make no promises whatsoever, to say, and it's like, look, we warrant nothing whatsoever about what we will do. We might try doing some content moderation. It will seem ad hoc and random and arbitrary, and then, try to shield themselves from potential deceptive practices claims. But I will point out that we see at the federal level more of this focus on unfair and deceptive trade practices around, like, what do companies do with people's user data, right? What do they do with the collection and use of data? And we already have that model of, in privacy policies, how companies explain and promise to users what they will and won't do with their data. Those promises have the benefit of being a little bit more objective and black and white. Not entirely. It can be difficult to parse exactly what sharing data with third parties actually means, or what it means for a company to draw inferences about your data. But I think there's certainly room for unfair and deceptive practices enforcement against how companies interact with users and the content and data they provide. I think the closer we get to that being applied to the qualitative evaluation of the merits of content, or even the subject matter or content of the content, it gets a little bit harder to see those clear, bright lines.
Great. So it's come up a couple times now, sort of the question about transparency, greater transparency, greater requirements about revealing kind of information. And I'll just say this is something in a report that we ended up not having much to say about, although we have some provisions about liability protection for data sharing. But actually, Mary Rose, you mentioned in the first part some of the limitations on the First Amendment sort of issues surrounding kind of transparency requirements. But I'd love to get your sense of, like, is there anything we can do kind of in this space about mandating transparency, right? And I think, like, for a lot of people, this seems like a real positive. Like, can we encourage or force platforms to just be more transparent about what they're doing and why they're doing it? Is there anything we can do in this space, I guess?
Well, first, let me just highlight that this is uncharted territory. So, as far as, some advice for Wendy and her friends who are interested in cleaning up the internet, I mean, they can really try to push and see what happens with transparency requirements. So, there's a way of trying to move the needle and push for, an analogy, say, to campaign finance disclosure requirements. There are transparency requirements that the court have upheld. So, that is a possibility. I was just flagging that, trying to, it kind of goes back to what Emma and Steve were saying about this term of service. The more you press for transparency, that will alter what they're doing behind the scenes in ways this is more like a practical reality. And I would just encourage everyone to talk more about, yes, there's the law, but there's also just the reality, like be careful what you wish for. So, you maybe these transparency laws will be upheld, but it might be in order to be easier to produce the records and so on, and to be more palatable to the reviewers, that they simplify what they're doing. They don't take down as much as we might as users want them to do, or as advertisers want them to do. So, that's the other piece that, I'm sorry, I should be more positive. I'm sorry. The positive is like, give it a shot. And you might win just because it is uncharted territory.
Yeah, I mean, I'm not a lawyer, and I think I also fall into this trap of thinking that like the law is clear on everything. I don't really have an appreciation that like, oh no, some things still need to be kind of worked out. Right, Delegate Goditis, I'd love to kind of follow up on where you spoke about a few minutes ago, and I'd love to sort of hear more about what your bill actually proposes. And how you think that's could really kind of benefit online discourse.
Well, I'd first like to point out that following all these brilliant legal minds and interpretations, it's all mutable. Whether it's an individual piece of legislation in an individual state, whether it's a company, social media companies, rules for themselves, rules that they set out for themselves, even interpretations of Virginia Constitution and the U.S. Constitution, it's all mutable. We have to understand this. Nothing that we say and do really, truly is set in stone. Going back to why I'm in this in the first place and the problem being too big, we have to try. We have to try. If it doesn't work out perfectly, I file another bill next year to adjust. This is the way it works. So again, if government is about protecting people, then we have to try to do that. The bill that I had tried to get through would have created, it's just a small first step. I don't know why it's so terrifying. It was to create a 20-member commission, some legislators, some experts, some ex officio representatives of the relevant secretariats in the state, 20-member commission to look at the problem, to understand, to look and see what impact it has had and is having. In the short terminology, when I'm speaking to groups about this, I say rhetoric that encourages violence, murder, suicide, sexual assault. To understand the impact, to see, is it having an impact? Where, who is it impacting? And to look at what is creating the impact. Is it the fact that this stuff gets promulgated? Is it targeted advertising? What is it that is creating this impact? And then trying to begin the process of having social media platforms work with researchers so that the data is made available so we can study it without risking people's personal data. Although having had my home address put out on the gun groups in 4 states, and people told to come to my house, right? We got to do something about this. This is absurd. So the commission would have just been a start to look at how we can protect Virginians in this very volatile phase of society that we're going through, and make a stab at figuring it out.
Great, thanks. Yeah, I mean, it's so funny. I mean, considering again coming back to this idea like the problem is too big. I mean, the proposal is, well, let's start studying this. You know, you know, this is one of the things that we really kind of latched onto in the report is there's a real space for states to provide just better understanding about what the problems are here, especially at the sort of local level. When, you know, my background is sort of as a social scientist studying misinformation, and like we so often kind of look at, you know, misinformation across platforms, right? Like, but there's a real need to sort of look at how problematic content or content moderation affects actual communities. And I you know, personally think there's like a real great opportunity for states to provide that sort of like, you know, better sort of like locally situated understanding. Emma, I think you mentioned in an email that you kind of also agree that like there's more that states can do here kind of as it relates to sort of understanding. I don't know if you wanted to follow up on that at all.
Yes, absolutely. And Delegate Gudaitis, I mean, the questions that you're asking and that you wanted the commission to ask, I think are exactly the right questions to be asking. They're ones that we're hearing in states across the country, at the federal level, overseas, in Europe, and around the world. Like I think there's really been a realization among the general public that we don't know that much about how our online information ecosystem works, how it affects people. There's a lot of good that comes from it, and there's a lot of things that cause a lot of people concern, and threats and harm and all sorts of negative consequences too. And one of the big challenges is that independent researchers don't have access to the data that they need to be able to study and understand these dynamics, to pick apart, you know, what kind of interventions work for solving which problems, what groups are most affected by both kind of content moderation decisions, you know, decisions to take content down, but also decisions not to take content down, not to address different kinds of abuse. And so that's where I think, especially, you know, to Scott's point, especially thinking about this at the state and local level, there's not a one-size-fits-all answer to any of these content moderation systems, not across different platforms, but also not for different groups of users. We need to understand a lot better how, you know, Hispanic-speaking population in Delaware is affected by disinformation, and whether that looks different from how, you know, folks in Northern Virginia are affected by disinformation. There are a lot of different communities, and state and local officials will be much more attuned to and plugged into the relevant dynamics than, you know, either Congress trying to order a study of the entire country all at once, or frankly, the social media companies themselves trying to understand what's going on. Social media companies try to think about issues at national and global scale and try to come up with content policies that work not just at the local level in Michigan, but also in Belgium and in Brazil. And it means that there's a lot of really important information about actual people and actual experiences that just doesn't get surfaced in these conversations. So I think that could be really a place for state and even local efforts to do a lot, characterize it. Sort of in anthropology, we'd call it ethnography, right? Really help explain what is happening in communities, good and bad, with their use of digital technologies. I think that would be a huge contribution.
Great. Yeah, so we amazingly only have 7 minutes left of our very short hour. And so I do want to open up some Q&A if anyone has any questions in the audience. I'll have an eye on the chat box. If not, I will ask the next question.
Scott, I just maybe if while you wait, I could just, you know, amplify something Emma was saying, which is, you know, studying and being very thoughtful about what exactly are the problems. So, you know, there are so many possibilities of the problems, and one problem area that has gotten a lot of attention that isn't really the subject of our conversation today is privacy. And so, you know, I know some privacy scholars are on this call listening in, so they'll be so glad I mentioned privacy. And, you know, there has been so much development on that front and an understanding of the problem that our personal data should be protected. And so you have an evolution of understanding and of the law so that it's changed. This does, you know, also amplify what Wendy was saying about how the law can change and it can evolve. You know, another area where the law is potentially evolving, say, is incitement. So The question of, how should the court define incitement for First Amendment purposes? Perhaps there should be a focus on litigating that issue. It may not have to be within this bigger legislative proposal, but there are very particular areas where there could be focused attention and moving the law for those particular problems, rather than like we're going to solve everything by repealing Section 230 or something like that, because that's just not going to work.
Scott, I'd like to applaud some of the understanding ideas and the investment ideas that are among the 13 that you and Matt came up with. I especially like the ideas of media literacy training in schools and communities. That will go a long way for helping consumers of regular media and social media to more appropriately discern and discover whether what they're hearing is true, or to, in some cases, just simply reveal for themselves the point of view of the person who produced the content. We can never have enough of that kind of media literacy. And in particular, I like it because as the NetChoice and CCIA lawsuits discussed, you need to focus on the source of the disinformation, the source of the content, and not on the particular platform they use to disseminate it. Because it brings me around to one of your ideas that empower the state medical boards to take enforcement on false health information. Initially, I thought that's a great idea. And then I started thinking through the lens of what would happen if a red state, for instance, had no problem at all with medical advice saying that under this latest outbreak of COVID, masks are not necessarily effective and the school should stay open. Well, the blue state next door has got plenty of users who would see it on their social media. And if that blue state ended up saying they think that is false health information, how could Twitter, Facebook, YouTube, or Donald Trump's social media network, how could they possibly satisfy both medical boards and avoid creating legal problems with a state patchwork of laws? I think it points out the fact that more of what you're recommending may have to be done at the national level.
Yeah, thanks, Steve. Yeah, no, I think that point's really well taken. Emma wanted to chime in real quick about the role that sort of state officials can play as sources of good information. So I'll turn to you.
Yeah, no, and it's a point that may raise some of the concerns that Steve was just raising about when we see conflicting information. But in a lot of the work that I've seen on disinformation and the problem of disinformation in particular, whether it's about elections or public health or anything else, a lot of times people who are trying to spread disinformation are exploiting the fact that there's not good information out there. And I just want to underscore that when state officials are thinking about what they and their offices and their agencies can do, being sources of authoritative, trustworthy information is huge. Filling up those data voids, making sure people know accurate information about state programs and policies, know that where they can find other sources of reliable information, making sure that information is available in all of the different languages that are spoken in your state or in your locality. We see in particular huge data voids in Spanish-speaking populations across the US that really are easy pickings for people who want to exploit and just try to get false narratives sewn into Spanish-speaking populations across the US. So that's a place where I think state officials can sometimes, forget just how much information and knowledge they have to share, and that a concerted effort in social media outreach and making websites accessible and really injecting good, high quality information into the public debate actually is a really necessary element of trying to combat things like disinformation.
Yeah, thank you so much. I mean, I could not agree more. And it's funny, when putting together some of the recommendations, was like, more funding for like state communication efforts, like seems not very sexy or like not very exciting, but like, oh yeah, could actually make some real help here. And I think one of the other things that we really settled on was just, besides like states, like state governments, like what are the other sort of, actors across communities that can produce good information and fill those data holes? And so that's why we ended up, suggesting like, more support for libraries and local news outlets. There's other sorts of key institutions. to have like a healthy communication system. So in our final minutes, I don't know if anyone has any like final parting thoughts, other big ideas things that states can do.
Scott, I would ask you to think about this. It's not just social media. Traditional media contributes more than social media to some of the worst disagreements we've had in this country on partisan basis. Harvard studied the COVID disinformation debate, and they studied the election disinformation debate. And more of the division in America was due to what they saw on CNN, MSNBC, and Fox than what they saw on social media. So your media literacy efforts, which are outstanding, should embrace traditional media as well as social media.
Yeah, and I would also add in the schools teaching students how to engage with each other across their differences more effectively. And that's something we're doing here at UNC as part of our strategic plan to promote democracy. But it's all not to put everything on the schools because they're already doing a lot, but I do think that would be helpful.
Great.
I want to say that I think it was last year's session, I was so frustrated by the loss of local newspapers, of the small local newspapers, and by the extreme partisanship of a lot of what we see on the big TV news outlets, that I did a commending resolution for independent journalists, because we need those voices. We need people with integrity who aren't being pressured from above to give one point of view.
Yeah, no, I could not agree more. So we're at time. I just want to thank you all again so much for joining on this, and it's been just fascinating to talk to you all. And for everyone else in the audience, thank you so much for coming, and feel free to reach out to us at the center if you want to talk about these things or anything else. And so thank you all.
Thank you so much.
Thank you.